Good morning. Welcome to another in our series of our weekly Meet the Experts Q&A sessions with Sintons Employment Team. My name is David Pritchard and I'm the Head of Marketing here at Sintons. Once again, and I know I do say this every week, but can we just thank you for so many people tuning in again this morning, all your comments, all your suggestions for questions, and the amount of people that are watching the videos afterwards. We don't take it for granted. We are very much appreciative of that, and we're really pleased that these sessions continue to provide some value to you. As with previous weeks, 3 questions our employment team will be answering. We've got a treat for you this morning as we have 3 of our employment team here as speakers. So we have Ailsa Hobson, Catherine Hope and Angela Carver. So without any further ado, I'm going to get off your screen, pass you straight over to Ailsa, who's going to start with question 1 of 3. Ailsa, good morning and over to you.
Good morning and thanks, David. Good morning, everyone, and just as David said, thank you again for joining us. So this week's Q&A is, I suppose, slightly different, as all of the questions are going to lead into one another and they're quite linked. We've already touched upon returning from furlough and returning to the office after lockdown in earlier Q&As, and so again this session follows on from those discussions and focuses on the potential risks attached to bringing those employees back from work, or in some instances insisting on it, who fall into the extremely vulnerable categories and who are currently shielding, at least anyway, until the beginning of August. It also includes those employees who do not fall into the extremely vulnerable category, but are still considered vulnerable. So this includes the over 70s and pregnant women. It also includes individuals with other health conditions that place them in a higher risk category. It's these people and those extremely vulnerable people that this Q&A is going to focus on, because it's for these people that we must consider the potential risk of disability discrimination. So to start with, I'm just going to cover what a disability is. So under Section 6 of the Equality Act, a disability is defined as a physical or mental impairment that has a substantial and long-term adverse effect on the ability to carry out normal day-to-day activities. Some conditions are deemed disabilities without this test. That includes blindness, excluding colour blindness, severe disfigurement, cancer, HIV and MS. There are also certain conditions that are not covered by the Equality Act. That includes things like alcohol abuse. So one caveat to this is a condition that's caused by alcoholism. So another disability, for example, like depression, can arise as a consequence of alcohol abuse. Depression could still be a disability where the actual alcoholism itself wouldn't. But again, the depression would be subject to the statutory test that I've just mentioned. So going through that in a bit more detail, does the person have a physical or mental impairment? So you're looking for a condition there. That usually comes down to medical evidence or any confirmation from their GP or consultant specialist. Does that impairment have an adverse effect on their ability to carry out normal day-to-day activities? So this is a low bar test and can include things like walking to work, the housework, as well as their duties in the workplace. Is that effect substantial? So this just means more than minimal. Again, it's a really low threshold. Is that effect long-term? So an impairment will have a long-term effect only if it's lasted at least 12 months, or is likely to last 12 months, or is likely to last for the rest of that person's life. So you might think that's quite a higher threshold. The middle one, is likely to last 12 months, is probably the one where you'd need more input from a medical specialist. Is it likely to last that amount of time? But if it has lasted at least 12 months, or it's a condition that we know generally lasts more than 12 months, then it will fall into that long-term effect category. So the relevant piece of legislation in today's questions is that those shielding or in the vulnerable groups are probably likely to have disabilities, and as such there are additional considerations and obligations that you as employers must consider before taking steps that could have the effect, and that's whether it's an intentional or otherwise. It could be something that you haven't really factored in, so it's just a wider consideration that you must have before taking steps of placing that person at a disadvantage. So Catherine followed by Angela are going to pick up on some of those obligations. Firstly, Catherine, I think she's going to look at disability arising from, and then Angela is going to look at reasonable adjustments. So they're 2 kind of very distinct pieces of legislation linked to disability under the Equality Act. So that's it from me. It was just an overview in terms of what a disability looks like and how that links to those shielding and vulnerable employees. And I'll pass you straight over to Catherine so that she can pick up on the first section. So over to you, Catherine.
Thanks, Ailsa. As Ailsa mentioned, we're looking at disability and within the COVID-19 pandemic. Now, one thing you need to think about within the COVID-19 pandemic in terms of potential discrimination claim is the claim where it's discrimination arising in consequence of a disability, not rather than it being direct. Now, this is covered by Section 15 of the Equality Act, and it happens when you're in a situation where a person, say person A, treats another person, so an employee B, unfavourably because of something arising in consequence of B's disability, and they can't show that that's a proportionate means of achieving a legitimate aim. Now, the classic example of this would be, for example, if you've got someone with a visual impairment and it affects their ability to carry out their role, they're slower than their colleagues, and their employer ultimately ends up dismissing them for low output. Another situation might be, for example, if someone suffers from depression and they have a number of short-term absences and their employer ends up making the decision to terminate due to their sickness absence level. So it's not because of the disability itself, it's because of that something arising in consequence. Now, in terms of the context of COVID-19, some things that could amount to that something would be, for example, if someone is required to shield because of their disability. Obviously, we have some changes coming in the next month, but also if someone makes that decision themselves to self-isolate, again, because of their concerns about the disability and the impact of the virus. Also, if there are ongoing restrictions in terms of their ability to attend their workplace, requiring them to work from home, or they decide to do that. As well, if you've got someone who suffers from extreme anxiety and depression, and they're unable to, because of that, to leave the house or attend their workplace when required. So those are just some of the things to think about. The requirement is unfavourable treatment. So it's important to note that there's not that need for comparator, or whether it's with direct discrimination. It's not less favourable treatment, it's unfavourable treatment. That's quite a low threshold. It's usually enough. It's not defined in the legislation, but it's enough for an employee to be able to reasonably show that they would have preferred to have been treated differently. In terms of how you look at it, it's broken down into two stages. So firstly, you'd be thinking about, does an employee's disability cause something, result in a consequence? Is there something that is caused by that disability? And secondly, is an employer treating that employee unfavourably because of that something? So there has to be that something that is a consequence of the disability. And when a tribunal is considering this kind of claim, they'll be looking at first identifying that unfavourable treatment and who's done that. They'll then be looking at what has caused that treatment. So then that's when they'll be looking at the decision-making process of the alleged discriminator, and they'll be looking at unconscious and conscious reasoning there. But what's important to note is the motive of that person is irrelevant. And they'll then be looking at, was the reason for the unfavourable treatment that something? So that's something arising in consequence of the disability. Now, an important thing to think about here is knowledge. Knowledge is required. An employer won't be liable for this kind of discrimination if they don't have knowledge or constructive knowledge of the disability. But you do need to be very careful there, because in a number of circumstances, it will be hard for you as an employer to argue that you wouldn't reasonably have been expected to have known about the disability. Employers are generally expected to do everything they reasonably can to find out if that's the case. So what I would say is, if you're dealing with a particular issue that's arisen, take the time and make sure you make those inquiries to see if there is an underlying issue. Are there signs that there could be something underlying? If there's an initial issue like someone being late for work, is there something that's causing that? Give the employee the opportunity to disclose that information, make those inquiries. What I'd also say as well is, if you have an employee or an agent, such as, for example, an occupational health professional, and they are made aware of the employee's disability, I think it would be harder for you to argue that you as the employer are not aware of that disability. So it's going to be important for you to put things in place so that information can be disclosed, confidentiality, there are appropriate channels there for hopefully for that information to be brought together so you can respond to it appropriately and fairly. that's just an overall overview of that. What I would say is that, and Angela will touch upon this, knowledge in terms of reasonable adjustments is a wider area. So it's different in terms of how they're both judged. So that's a quick overview of that. I'll pass you on to Angela, who's going to finish off in terms of reasonable adjustments. Thanks.
Thanks, Catherine, and good morning, everybody. I'm going to look at reasonable adjustments. Reasonable adjustments are actually unique to the protected characteristic of disability, so that it doesn't come in relation to any of the other 8 characteristics under the Equality Act. What you will tend to find with reasonable adjustments is that a claim will also be brought for discrimination arising from a disability, as Catherine's discussed, and more than likely indirect discrimination as well. What tends to happen is people will put everything into the basket and give it a shot, really. As Ailsa's identified, most shielding employees will likely be covered by the Equality Act, as those who are suffering from disabilities. So there's certain things that you do need to be very mindful of when shielding employees are returning to the workplace. So you need to look at things such as the condition that the individual suffered from pre-COVID, whether anything's changed in relation to that condition. Is it a brand new condition? So were you wholly unaware prior to lockdown? Has anything changed in relation to the individual's job, the job function, or the place of work, which could have an impact? And key, have you undertaken your COVID-19 risk assessment? If you haven't, our seminar from last month is on the website. Please have a look at that. We discussed that in detail. And does that individual require a specific workplace assessment? What I can't stress enough is when you have done your risk assessment, you need to communicate the outcome to the employee so that they understand what you've put in place, what the risks are and what they need to do. One thing you should be bearing in mind is that employees will be nervous about returning to work. The recent government stats show that there are about 2.2 million people who've been asked to shield, who as of the 1st of August will be adopting strict social distancing rather than shielding. And that's where your reasonable adjustments come in the workplace. So reasonable adjustments come in 3 forms. First is the employer's duty to provide an auxiliary aid for an individual who may need it. The issue of physical features of a premises, and what we call a PCP, which is what I'm going to concentrate on, which is a provision, criterion or practice. So just to note, the duty to make reasonable adjustments isn't an absolute. You don't have to always do it. It will only arise where you know or ought to know of a disability, as Catherine's touched on there. That's the knowledge point. And there's also knowledge that there will be a substantial disadvantage to that individual. Knowledge is an entire topic on its own, which we don't have time to go into today, but it is a defence to a claim for discrimination before the tribunal. The threshold is quite low. An employee will undoubtedly say my GP records, my presentation, what I've told you, all clearly pointed towards disability. So how could you possibly not know? And in a lot of situations they will pass the bar. So substantial disadvantage, well, what does that actually mean? Unhelpfully, it just means more than minor or trivial. Again, it's quite a low threshold, so it's often relatively easy for a tribunal to conclude that an individual has suffered from a disadvantage. What you will tend to find with the shielding employees, though, is that you may already know. You'll know that they potentially suffer from a disability and you might already have put something in place for them. But when you're looking at this PCP, the provision, criterion and practice, what the employee needs to show is that you've put something in place, your PCP, which is a result of the disability suffered from that individual. They are placed at a substantial disadvantage in comparison to those who are not disabled. And a few that we've had come through recently, my employers put a PCP in place that staff can't use the on-site car park to avoid congregation, obviously trying to avoid the risk of contracting COVID. This places me at a substantial disadvantage because I can't park near the door, and due to my physical disability, the multi-story is too far. My employers put a PCP in place using a one-way system. The lifts go up, the stairs go down. I can't use the stairs because I have a physical disability. My employers put a PCP in place that the fridges in the workplace can't be used to avoid congregation in kitchen areas and multiple personnel using the fridges. This places me at a substantial disadvantage because I can't store my insulin in the fridge for my diabetes. So first and foremost, step back and take stock. as an employee, you might want everybody to return to work, but you do have to remember you've got that overarching duty to ensure health and safety of all of your staff. If your previously shielding employee comes to you with a request for an adjustment to their role or raises a concern, you really do need to consider it. I would, however, stress that a reasonable adjustment needs to be reasonable for all, not just the employee. And if you can't put the adjustment in place for a very legitimate and proportionate reason, then this could be a defence to you not doing it. It's what we call the defence of proportionality. So I would look at things such as, can the individual continue to work from home? Can they remain on furlough under the scheme, obviously as it's amended throughout the months? But if you need them back, can you look at permitting car parking for exceptional circumstances, permitting staff who can't use the stairs access to the lifts, offering that individual a fridge for the sole purpose of using their insulin, amended hours, varying a role, modifying equipment? Do you need to consider setups of a workstation? A lot of employers have reconfigured their workplaces to avoid risks from COVID. Can you stagger start times? Can you avoid rush hour for travel? And actually, is your place of work safe? If you can't reach an agreement with your member of staff, you could be looking at things like holiday pay or unpaid leave, but I would move into these with caution, because again, that could be a potential detriment. There's a couple of cases that came out quite recently, and the Court of Appeal has very clearly said that what they said is the objective assessment of the reasonableness of proposed adjustments needs to be looked at as a balancing exercise. And this was reiterated in a case with the DWP just last month in the Employment Appeals Tribunal. And it's a balance between the disadvantage suffered from the individual versus the needs of the employer. And it is going to be subjective, and it's not going to be one size fits all. What I just say is use this time before the 1st of August to have a look at your workplace, have a chat with your members of staff, figure out what's going on and try to reach some kind of compromise. Have that in mind that you do have a duty to make adjustments if somebody is disabled or could be disabled and will suffer a disadvantage from something you've put in place. Now, this topic is massive, and the three of us could talk about it all day if we had to, and often we do. So if you do have concerns that have arisen out of today, please just contact us and we can talk you through any concerns you might have. So that's all from me, so I will pass you back to David. Thank you very much.
Thank you, all of you. Just a quick reminder from me, we are producing lots of relevant and useful content, all of which can be found on our website at www.sintons.co.uk should you wish to take a look, and that includes articles, blogs, podcasts. Catherine put a really good podcast up yesterday about settlement agreements, which is definitely worth a listen. Also videos and Q&A sessions like this one, and all previous episodes of this Q&A session can be found on the website as well. Also, you can follow the team on Twitter at Sintons HR. I've just popped the team's details up there. If you'd like to discuss anything they've raised today further, please don't hesitate to get in touch with them, anything employment related. Also, if you have any other legal inquiry, please don't hesitate to get in touch with the firm. Our next session will be next Friday at 10 AM on Teams, and as usual, I'll send the link around to you after the weekend. Once again, thank you very much for tuning in. From Ailsa, Catherine, Angela, and myself, thank you very much. Stay safe, everyone. We hope you have a great weekend, and we look forward to speaking to you next week. Thank you.